Good morning. I was rather hoping that we might address or talk to Atalia, because if anyone's going to be the future of computational law, she is, but I think she's otherwise engaged. We're very pleased to be able to share with you the preliminary findings, because it's a draft, of our research study on computational law. And our research study looked at the core concerns of the project. It looked at the implications of code-driven and data-driven legal technologies for law's mode of existence, how law exists, for the rule of law, and for the nature of the protection afforded by law. And in this respect, much of the groundwork, as Mariah explained, much of the groundwork for our research study was laid by the research study on text-driven law, where the team explored law as we know it as an affordance of text and the printing press, and in turn explored the rule of law and legal protection as affordances of law as we know it, of modern positive law. And we see from that research study that law as we know it, law in its current mode of existence, because it is text-driven, affords contestability, it affords interpretability, it affords citizen participation because we can understand it, because it involves the exercise of legal reasoning, and it affords accountability, all of these being values which we associate with the rule of law. And in that respect, it respects the autonomy of the individual because it allows us to actively participate in the discourse of law. Crucially, in law's text-driven mode of existence, legal effect, the binding character of law, is ascribed, whether authoritatively by the courts or not, through the exercise of legal reasoning and interpretation. And here we see what, we've attempted to represent it diagrammatically, what Bruno Latour might have called the constant tracing and retracing of connections between speech acts of the law, words that do things in law, persons, facts, actions, texts, and legal effects. And we hope to convey here that law is much more than a bag of rules, but rather it is law in action and involves the ascription of legal effect. And this, I think, is significant for how we assess the implications of code-driven and data-driven legal technologies. So I'm going to look at the implications of data-driven legal technologies. Laurence will look at code-driven. And in order to carry out that analysis, our starting point has been to look, as Mariah indicated, to look at the affordances of the technologies. What action potential do they allow us in their context of use? And for data-driven technologies, we have suggested that these action possibilities, these affordances, can be grouped into three very broad categories, that they allow us enhanced legal search through the use of contextual search and contextual search, and that they allow us to generate new insights. These technologies allow us to generate new insights from the data which we have. And of course, they allow us to generate text. So if we think, for example, of a system like CoCounsel, which will allow you to create the first draft of a legal brief. But it's very important to remember that these are action possibilities which ordinarily would require language understanding and human reasoning, and that neither of these abilities are present in the context of data-driven systems. That under the hood, what's going on with the outputs of these systems is, of course, as we know, very different from the processes which we engage in when we are engaging in legal reasoning. And with that in mind, we can understand these systems as both change agents and influencers through the affordances, the action possibilities they allow us. And in relation to data-driven legal technologies, we've suggested that we can understand that influence under three broad categories. We can understand them as engines of influence, as seats of power, and as allowing for or making way for a new normativity in law. And here we only explore two, this idea of them operating as engines of influence, and they're making way for a new normativity. And the first I suggest is the here and now of data-driven legal technologies, where we already see that systems that afford contract review or contract analytics, sophisticated legal research tools, predictive analytics, document generation, these may have an effect on legal effect in two different ways. They may shape the outcomes to which legal effect is ascribed. And what I mean by that is, if these tools are used by lawyers, they will inevitably influence, not dictate, but influence the output of their work, and therefore shape their clients' actions and shape the outcomes to which legal effect is ascribed. But also, perhaps more significantly, they may shape the authoritative ascription of legal effect, by which I mean they may affect the actual judgments of the courts. And if anyone thinks that that is implausible, we already see the use of data-driven technologies, in this case, ChatGPT, not specifically a legal technology, but we also already see the use of these systems by judges to inform part of their rulings. Here we see Lord Justice Burst saying that ChatGPT was jolly useful, I should say, for those purposes. I've said that these systems don't dictate. There are constraints on the influence of these systems. Those constraints include the duties of independence of lawyers, or duties of competence, and similarly, the obligations on judges to be independent. So these are things which should operate as buffers in relation to the influence of these systems, and it's difficult to know to what extent these systems may actively shape. We know that they will shape, but we don't know exactly how. We know that they will shape legal practice and how legal practice emerges, but it's difficult to concretely say how. However, we also, apart from addressing the here and now, we also confront how in future we may make way for a new form of data-driven normativity in law. And we may do this if collectively we make the mistake of imagining that the outputs of these systems and human legal reasoning and interpretation are in some way equivalent. If we forget that the processes by which they are produced are very different. And if that happens, I suggest that what we may see is a move from use of these tools for decision support to use in decision-making. And the apotheosis of this, if you like, is that we see their use in decision-making by judges. And again, if one thinks that's implausible, we already see that judges are actively contemplating the use of these systems for, at first, very minor decisions. What would the implications be if we made that mistake? If we treated the outputs of human reasoning, human legal reasoning, as equivalent in some way to the outputs of these systems? We can address that in two ways. We can address that with reference to the current state of the art of these systems. And we know, many in the room will know much better than I, that these systems suffer from various problems, some of them technical problems, some of them social problems, some of them broadly environmental problems. And I list these here. The one that I'm going to focus on is the issue that these systems are currently unable to produce legally relevant justifications. So they may produce what looks colourably like a decision, but they can't explain why in a way that maps to legal reasoning. And that has obvious difficulties. These difficulties have been addressed by others, including, for example, John Tassiulis. where we see there are problems in relation to the European Convention of Human Rights, in relation to Article 6 and the right to a fair trial, or Article 13 in respect of the right to an effective remedy. Because, of course, if these systems can't provide legally relevant justifications, there are issues for the values of contestability, accountability, and the possibility of participation in the discourse of law. But let's imagine, as Volock does, he carries out a thought experiment which has been explored by others. Let's imagine that these systems can solve some of their technical problems. Let's imagine that they can produce what colourably looks like justifications. And I can tell you that active research is being done at the moment in an attempt to replicate what looks like justifications produced by human legal reasoning. And I suggest that even if we got to that stage, this is problematic. And it's problematic, I suggest, because if we delegate judging to systems like these, to the extent that we do that, we cease to participate in that activity. We cease to find ourselves in a position to hold these systems accountable insofar as we delegate that social responsibility to these machines. And so we suggest that there is a problem, therefore, even in this situation, for accountability, and perhaps especially for participation. So that in either case, either given the state of the art of the systems now, or on some future imaginary where these systems sort out their various technical problems, we may see a very different kind of normativity from law as we know it, and a very different source and form of legal effect. And I find it difficult to understand how we collectively as humans can engage in the discourse of produced by systems that are used effectively for this kind of judging and decision-making. And with that, I will hand over to Laurence to discuss the implications of code-driven legal technologies.
Thank you, Pauline. Feels weird holding the microphone, but okay. Right, so as Pauline says, I'm going to briefly take a look at the potential impacts of code-driven law. I'll start with the definition that we adopt of code-driven law because there's no single way of thinking about it. So in the project, we think of it in terms of legal norms or policies that have been articulated in computer code by a public administrator or the legislator. And this is the quotation of the definition taken from Professor Hildebrandt's chapter from 2020. We shifted away in the project from looking at blockchain and cryptographic quote-unquote law. Obviously, the efficacy of those things have been deeply questioned in the last year to 18 months. Although they do have some relevance for private law purposes, the emergence of rules as code in the last, or the ascendance, let's say, of it in the last 18 months, 2 years, 3 or 4 years, something like that, is particularly salient from a rule of law perspective because, of course, those rules are coming from the legislature. So there are implications there which are centrally relevant to the Cubicle project. So that's the focus of that chapter of the research study and of the code-driven element of the project more generally. Now, thinking about the lens that Cubicle applies, I'll probably repeat a little bit some of what Pauline said in terms of different normativities. One aspect of the lens that the project looks at these issues through is through this idea of there being different types of normativity or different types of kind of guiding force that different technologies can impose upon a practice or can shape a practice with or can constitute a practice. On the one hand, text-driven normativity comes from text, as Pauline has already described. That gives law its particular character. It's what makes it legal. It's what makes that adjective have meaning, legal. And that includes the capacity to balance the certainty of outcomes, policy goals, and justice. That's what Professor Hildebrandt was referring to in relation to Radbruch earlier on. It also provides the possibility of protection. So the ability of law to protect us as citizens, as individuals, as collectives, is an affordance of text as a technology. On the other hand, we've got technological normativity, so how digital architectures constitute, regulate our behavior, shape our practices, and the things that are built around those practices and the artifacts that lie at the heart of them. Both these types of normativity have very different affordances, and they have, in the legal context, they have quite different ideas of what it is, what a rule is, what the concept of a rule is. Text as a technology affords slowness, it affords delay, it affords interpretation, disagreement. Code, on the other hand, code-driven technologies, they afford speed, they afford certainty, they afford a certain power to the designer of the code, to the person who translates the rules into the digital architecture. Now, in the context of rules as code, this applies at two levels, I think. On the one hand, it applies to the way in which the rules, the translated rules themselves are imposed upon us as citizens, but it also applies in the architectures and the processes by which those rules are created. So the mechanisms, the tools, the approaches, the practices that are used to actually develop the rules are themselves shaped by the technologies that are used there. It's not just the rules that come out of the process, it's also the way the rules are created. So we can think of, that's all quite abstract, we can think of different rules as code approaches or techniques, I think on a spectrum. So a spectrum that on one side is, we find legal normativity that's based on text, which facilitates the concept of legality. So there we have the idea that rules don't self-impose, that there's an openness, there's the chance that we have to interpret what the rule should mean, the choice even to ignore the rule if that's what we decide to do, and to make sense of it in terms of the context in which it may or may not apply. And then at the other end, we've got technological normativity. So the rules are entirely code-driven. There's no kind of phase in which they are natural language. They go straight into computer code. They self-enforce. Those that are subject to them, their behavior is shaped, perhaps even defined from the outset. And that's a form of, or that reflects the idea of legalism in contrast to legality. And when that's done computationally, we get a very particular, strong form of legalism. So those are extremes of a spectrum. Those are extremes of a spectrum. But we can think of different rules as code approaches as lying on that spectrum. So they can be at different points in between. And in the research study, we identified three main classes of rules as code technologies. So towards the left of the spectrum, towards legal normativity, we've got systems that provide like legal metadata that structure documents in such a way that you can specify how the legally meaningful parts of the documents, you can specify what they are within the document. The most obvious example being the elements of a piece of legislation. Those systems, they afford reference to specific elements of the law. They afford finer-grained research, finer-grained search. You can perhaps scope your search in a way which is more precise than with kind of traditional search approaches. You can cite specific pieces of legislation or elements of legislation more precisely. There's other affordances, for example, the versioning of legal texts, the capacity to archive them more effectively, and also to understand the evolution of law over time. So you can, for example, do a point-in-time analysis where you can see at this given moment, this was the state of the law. And that kind of fine-grained tagging, structuring of documents is what facilitates that. And in principle, the rules which are represented there are still entirely natural language. They're all text-based, but the form in which they are stored and manipulated, the digital form, is augmented with new affordances, things that go beyond a standard printed sheet of paper. Towards the center of the spectrum, we've got policy development and logical checking type systems. So there, the development of the rules, the processes by which rules are developed within a legislature, within an executive, is adapted to facilitate collaboration between the teams that are involved there. So you take a kind of design thinking perspective. The idea being that in the end, the rules which come out of that process better reflect the policy intentions of the legislature. allied to that, and one part of that process that's commonly used, is formalizing the structure of documents, not the meaning, but the structure of documents, and using that to check the logic of those documents. The idea being that you can avoid like logical impossibilities coming up. And in the end, again, the resulting document, the resulting rules are still text-based, they're still natural language, but the ideas, the hope is that they're better quality, because they better reflect the policy intent and they don't have normative or logical holes in them, which might cause trouble down the line. Further towards the right-hand side of the spectrum, we've got bespoke languages, computer languages which are designed specifically for the representation of rules. They're the idea, and there's lots of examples here, so I'm not going to go into any detail in them, but the idea, roughly speaking, is to directly write the policy into an executable language. This reduces the gap between the writing of rules and the ability to implement those rules or to enforce those rules. And the goal is to reduce the cost of implementation, is to improve the notion of compliance, particularly by third parties, because they can access these rules and they can implement them directly into their own digital systems. So the translation gap is collapsed, the delay of ordinary text-driven rules is reduced, and the idea is that that will have lots of benefits. So across that spectrum, and that's a very, very brief and rough description, across that spectrum there are multiple new affordances on top of text. And I do think there are some real potential benefits with some of those classes of system and the specific systems within them. But there are also potential concerns, quite a few potential concerns. And I think we do need to ask some pretty significant, profound questions about how these systems are going to be adopted in practice. Firstly, there's a risk, quite a large risk, I think, that we might tend towards a technocratic understanding of what legal rules are and what it is to comply with legal rules. We've heard both from Pauline and from Professor Hildebrandt, the nature of legal rules is not one of do this, you are under command. There's more going on than just the rule itself. And from the citizen's perspective, there's a potential that we might shift to a more top-down control rather than a bottom-up autonomy kind of view of what legal rules are. That's problematic. There's also the risk that, to an extent, lawyers could be de-skilled. Their professional task is not just to apply rules, it's to interpret rules in light of context and in light of the interests of their clients, and to mix all of those things together and to produce some kind of new piece of reasoning which is going to best protect the interests of their client. And if too much of that is automated, it's unclear, of course, I can't be categorical about this, but it's unclear precisely what their role in legal protection will be. Will they become agents of compliance, or will their role in balancing the power of the state to impose rules be maintained? On the other hand, taking away some of what they do might free them up to do some of these other things, to better understand the needs of their clients, to have a more kind of quote-unquote social role. But empirical work, I think, would be needed to know that. But the point is that we can't just assume in advance precisely what the impact will be. Another potential benefit, I think, is this idea of design thinking. It could well be that by properly investigating the needs of the users of the legal system and the actors involved in the legal system, including lawyers, including judges, but also, of course, including you and I as citizens, we can better understand what's actually required to meet the goals and the aspirations of legal protection and the rule of law. So I do think there's room there for real benefit to be had, but we need to think about what it is that we want to achieve and how we're going to achieve it. Moving on from individuals affected, thinking about the broader system, I think there's a real risk that rules as code might create additional complexity rather than reducing complexity. It could be that if you create rules as code translations in one area of law, you effectively commit yourself to creating them in another area of law in order to make the first set work. So I'm thinking, for example, you might need to think about what it means to interpret, what the procedural requirements are, and that might then require additional code-driven rules to facilitate that. So we need to think about how the text and the code rules will relate to one another, maybe some kind of API between code-driven law and text-driven law, with interfaces that allow for the code-driven parts, the automated parts, to properly integrate into the text-driven elements, ensuring all the time that the dynamics of code don't undermine the affordances of text, because that's ultimately what protects us. And then maintenance. If the rules are out of date, if they're incorrectly translated, that's bad enough when the rules are text-driven. When your lawyer makes a poor interpretation, or you make a poor interpretation of a rule. But when those are automated, of course, the impacts are potentially much more significant. And liability for when things go wrong. We might need a new regime to handle that. And moving on from the system, what about the theoretical foundations of the law? So big questions here. Who gets to interpret the translation of law into code? Who gets to do that? It's not enough to have legal experts in the room. Legal experts, doesn't matter how expert they are not constitutionally authorized to declare the meaning of a legal rule. That is solely and entirely the role of the court. And again, if those interpretations are automated using technological normativity, not text-driven normativity, the effects are quite different. It's one thing, again, for someone to misinterpret the law when it's text-driven, but it's quite another for them to then embed that misinterpretation in an automated system that could have effects for millions of people. Not that it's about numbers, but yeah, the principle stands. And the role of discretion. So I mentioned legality before. Legality requires discretion. It requires the spaces to be open that that prevent rules from self-enforcing, that allow us to interpret them in context. I'm thinking here of Michael Lipsky's work on street-level bureaucrats. I think that's extremely relevant here. In practice, even under text-driven law, the law is mediated by people on the ground who actually facilitate it in context, in response to complex social environments. There's a potential, I think a strong potential, that rules as code might displace some of that, and that could undermine the flexibility that's inherent in just application of the law. More importantly, the medium, I think, might shape the policy. So the perceived benefits of rules as code, the reduction in costs, the increased efficiency, higher compliance rates, might mean that there's a push. And I think it's already evident in some of the literature that's out there. It might mean that there's a push to formalize more areas of law which previously were deemed to be unformalizable or inappropriate for formalization. So classically, fiscal rules are what is the current focus, but I suspect, and as I say, I think there are hints towards the likelihood that that will be expanded in certain quarters, perhaps by people who have the best of intentions but might not fully understand the implications. But perhaps more troubling, and this may be I don't know, a bit extreme, there's, I think, a concern that upstream in the policy development process, policymakers start to favor ideas that are formalizable per se. And if they do that, that means that things which are not formalizable per se kind of fall out of the purview of policymakers. They kind of start to only see things which can be computationalized. And I don't know if that's likely. I don't know if that's going to happen. But if the effectiveness of a piece of policy is measured according to computational means, then it stands to reason that people are going to start to formalize, to develop policy only in things that can be formalized, and that's potentially quite worrying. Lastly, the mirage of human readable code. This is problematic because I think if the code looks too human readable, it might mislead people into thinking that it's text-driven normativity, when in fact, in reality, when it's enforced, when it's imposed via technological normativity. So there's a potential mismatch there, where people believe that it's going to act in one way, or it's going to operate in one way with the affordances of text-driven law, but in fact it's going to operate in a code-driven manner. And the distinction is significant enough that it could well be that some formalizations ought not to be human readable, or they ought not to be citizen readable. Maybe by experts, fine, but not by ordinary people who might misunderstand what it is that they're looking at. So ultimately, that hints, I think, at something that Pauline raised, which is that we're talking about different modes of existence of a rule. We're talking about, on the one hand, the text-driven mode of existence, and on the other, the code-driven. And this relates to the notion of legal effect. I'm kind of a bit behind time here, so I'll go quickly. There are, I think, two, slightly different from what Pauline said, because I think the implications are different for code-driven. There are two different potential effect, classes of effect and legal effect. On the one hand, how legal effects are attributed in a given situation. For example, the legal technology shapes the process by which you reach a determination of legal effect. So, for example, the different access to legal materials, improved search, the ability to develop a better, more creative argument because you've got a better understanding of the legal landscape. That's extremely valuable, potentially positive. On the other hand, there's the very concept of legal effect being changed. And I think systems towards the right of the spectrum, ones that are more technologically normative, that are more based on code and less on text-driven legal normativity, they might well tend towards changing the concept of legal effect, not the method by which it's arrived at, but the very concept. Because when you put more of the infrastructure, more of the practice into code, out of text and into code, you necessarily have to translate the concepts of the practice into code. And we're talking about categorical difference here. We're talking about two different modes of existence. The translation that occurs depends on the programmer's understanding of those concepts, but the possibilities within software architecture are quite different from the possibilities within a legal architecture. So rights become permissions, citizens become users, we have access control lists instead of rights and duties, so on and so forth. They might seem intuitive from a computer science perspective, but they are not analogous to their legal supposed counterparts. So, to sum up, I think we can absolutely use computation as a tool to improve practice. We ought to. There are huge possibilities, but as long as we don't replace legal effect, either explicitly or de facto, both data-driven and code-driven systems have great potential to enhance legal protection and the rule of law, but we really need to assess the change. We need to go into it with the right starting point, the right perspective. We need to assess how the concept of legal protection might be affected and what the dependencies of that concept are, in order that those dependencies are not undermined. Does the change maintain or maybe enhance legal normativity? And coming back to that word legal, that adjective means something, and we have to bear in mind what it means, and we have to ensure that it's maintained, that it's preserved, that it's strengthened. But we can use computation to do that. We just need to be very clear and nuanced about how. So I'll stop there, and thank you very much.